We can get started now. Welcome to our panel. This panel is going to be very interesting, in my opinion. We're in Canada, so it's the fight for international human rights in Canada. And I would like to introduce our first speaker today, Izabella Khachatryan. Izabella is a alumni of CFTJ. She's been with us since our inception. She studies at the American University of Armenia, and she just submitted her thesis on drone attacks and the impact of using drones and completed her master's program. Ms. Khachatryan, please join us.
Thank you, Ms. Pisikian, for introduction. Hello, everyone. So today the topic on which I'm going to do my speech is about the UAVs. UAVs used in the modern warfare and the risk, and also IHL, International Humanitarian Law Principles. So there is no doubt that conventional wars and modern warfare cause dreadful impact, instability in societies, increasing civilian injuries, and other conflicts, and other dreadful impacts on human lives. So the conducted research helped me to acknowledge and differentiate the main types and categories of UAVs and also their capacities. And the main failure of the system occurs to be or malfunction due to the fast changing and constantly changing environment where the drones are engaged in. Also, other factors that play a huge role in the failure of the system could be the drone videos, signal intelligence, human intelligence, data crash, etc. Mentioning those factors, I guess it's also important to mention the strike types that could be signature type or personality, as well as operating framework, which can be pre-planned or dynamic ones. So all these factors could give false confidence to operating units and thus reach to mistargeting. And by mistargeting, there can be breach of several IHL principles. Mainly, I'm going to mention the distinction principle, proportionality, and military advantage. There are already reports which documented such violation by Human Rights Ombudsman of Republic of Artsakh in Armenia. However, the testimonies gained from military doctors during the CFTJ clinic helped me to get more copious evidence on the matter. So the principle of distinction, which is to have a legitimate target, was somehow vanished or blurred because the doctors who were wearing uniforms, medical uniforms with specific emblems, and also driving cars, emergency car and ambulance cars with protective emblems were targeted. The result is expected. So they were medical personnel who got injured and even died. In the scope of distinction, there is also military objects and civilian objects and hospitals. So they also were targeted, even though having the specific emblems on them. And again, the results were the injured doctors and also the doctors who gave me the testimony reported of losing their friends in this case when they were showing medical support. In scope of military advantage, it's the humanity option is somehow gone because the UAVs are not concerning whether to accept the surrender, they're just kill, and the term "eau de combat" simply vanishes in this case. So again, doctors in their testimonies mentioned that it's a mere of luck that they were alive and they were able to give these testimonies. Also, the doctors were participating in a 2016 four-day war, and it also helped me to somehow understand what injuries the soldiers got and what kind of traumas the doctors were dealing. So it led to think that those injuries were superfluous and causing unnecessary suffering because compared to 2016-2020, injuries were mainly burns, shrapnel injuries, and other traumas which lead to longer rehabilitation process, or you know that the mortality rate of this 2020 war was very high. Compared to 2016, they were simply gunshots gunshots in the lower and upper parts of the bodies of soldiers, and also some nervous pathologies, PTSD, etc. Therefore, drones should be scrutinized separately, the system which they are operating and also the weapons they carry, because the illegal actions occur from these two subjects. And consequently, now we think that UAVs are not prohibited, and there is no prohibition or ban on those means of warfare. However, the naturally emerging call is to have some specific limitation, and also specific limitation on arm control on the UAVs, because this now that it is concerned that modern armed conflicts are going to have some limits, which is that quote that even wars have limits. Now it seems that modern armed conflicts to be much tenser, disproportionate, unlimited, leading to unfair juxtaposition of the life of human life and a machine. Thank you for your attention.
Thank you, Ms. Khachatryan. Our next speaker is Kelsey Gallagher, a researcher and author with Project Plowshares, a peace research institute of the Canadian Council of Churches that works with churches, governments, and civil society in Canada and abroad to advance policies and actions to prevent war and armed violence and build peace. Mr. Gallagher's research focuses on the Canadian arms trade. He monitors Canada's export of conventional weapons and their use in conflict abroad. Specifically, Mr. Gallagher studied exports of Canadian drone technology to Turkey. He also maintains the Canadian Military Industry Database, which is the most comprehensive database of Canadian arms exports available. He holds a master's degree in peace and conflict studies from Conrad Grebel University College, University of Waterloo, and a bachelor's degree in political science from Western University. Mr. Gallagher, welcome and thank you for being with us today.
Thank you. Can you hear me? Just setting my timer here. Oh God, I'm cutting into my own time right now. There we go. Okay. Thanks so much for having me. So my name is Kelsey Gallagher, as mentioned. I work with an organization called Project Plowshares. We're one of Canada's oldest peace research organizations. And one of our topics is the Canadian arms trade. So we systematically track Canadian military exports to ensure that they're not being used to contravene IHL, for instance. They're not being diverted to illicit third parties. And that they're being exported within Canada's obligations under the Arms Trade Treaty, to which it's been a party since 2019. All right. So a lot of our discussion today is going to focus on this drone, the Bayraktar TB2. I think most people in the room know what this is. So this is a Turkish-made drone. This is actually Turkey's first drone that's been domestically produced and exported in any sort of serious volume. It's been sold or exported to over 10 countries now. Some are kind of in a contract phase. And its first real splash was following the 2020 war in Nagorno-Karabakh. So despite this drone being a real node of Turkish pride and being ostensibly Turkish made, it does rely on or relied on a series of foreign sourced components. One of them, arguably the most important, is referred to as CMX 15D, and this is made by a Canadian company called L3Harris Westcam. So I won't go into the weeds, but what this does is essentially acts as the eyes of the drone. So without this component or one like it, a drone can't essentially see targets or target anything. And with this particular component, it actually can't fire. This has a laser designator. So Within this component, this enables the drone to actually fire a smart munition, which of course were used in Nagorno-Karabakh. So it's actually hard not to understate how integral this component is, because without this drone can't really fly a combat operation. So between 2017 and 2020, the Canadian government authorized about $300 million worth of exports of these sensors to Turkey. It temporarily paused these exports in 2019 following Turkey's invasion of Syria, and then quietly reintroduced or reversed that policy, which we later found out about. And although this technology is actually no longer being supplied to Turkey, it played a critical role in the development of this drone, and has proliferated again to Nagorno-Karabakh and other places. All right, so as an arms control watchdog, one of the things we do is once again to systematically track where Canadian components go, where weapons go, to once again ensure that they're not being used to violate human rights, they're not being diverted, and so forth. There's many ways how we do this. We rely on a bunch of different data sets. We've also started employing some open source information. There was actually a great panel yesterday that discussed this. Here are a couple images actually of Westcam sensors downed in conflict zones. And we can look at these and positively identify them as Canadian technology. So in the top right, we have a sensor downed actually in Syria. We can see this is actually, the sticker is a proprietary sticker that Westcam uses. It's called a laser warning sticker. On the left, we have a unit that's downed in Tarhuna in Libya. So this is particularly troublesome, the case of Libya. And the reason why that is this is the first time that we knew that these weapons were being diverted. So diversion occurs when a weapon system is re-exported by the initial importer to an illicit third party. That's an illicit activity, and in many ways you could call it illegal. Canada is a party to the Arms Trade Treaty, and as such, when it learns about any instances of diversion, it actually has to act to interrupt those and stop them. This was in 2020 or so, or 2019. So in this case, Turkey is diverting these sensors on the actual drones itself. Another way that we've tracked their proliferation is through propaganda actually released by different governments. So this is obviously like a classic example of this sort of thing. 1940s UK. It looks more like this today. So this is actually the feed from a Westcam sensor released. This is actually a promotional material, but this is what a drone operator sees when they're conducting an operation. This is not a combat situation. This was actually taken from police monitoring people breaking COVID protocols in the US. But the reason why this is important is we took these images apart and put together what's called the graphical user interface, which is all of these images on the outside of the screen. And when these appear on a drone, in a drone operation, we actually know that this is made by Westcam, which is the manufacturer of these sensors. So we know that a Canadian sensor is actually being used in these operations. An example of what it doesn't look like, this is a Lockheed Martin, US-made EOIR sensor, which is what we'd call them. So once again, this is a Canadian sensor. So we could take these, once we knew what the actual sensor interface looked like, and start looking at actual drone strikes. So this is a Turkish assassination of a PKK leader, Ismail Ozdin, in Iraq in 2019. And although it's blurred, and that's for operational security, you can see that obviously the graphical user interface is congruent, right? So we now know that this airstrike was undertaken with a Canadian sensor. So where does this go? So we put all of this together and actually released a major report in 2020 and argued that Canada must stop the provision of this technology to Turkey under its obligations as per the Arms Trade Treaty. There was a substantial risk that these weapons would be used to violate IHL or in IHL violations, considering how Turkey had conducted airstrikes. And on top of that, there was obviously evidence that they had been diverted, or at least corroborating evidence that that was possible. About 3 days after we released this report, the war in Nagorno-Karabakh kicked off again. throughout the summer, there was reports that Turkey had entered into a contract with Azerbaijan to provide a number of UAVs, 23 or so, and we were tracking that at the time as well, and it was our assessment that they were probably actually going to come with Canadian hardware. Turkey didn't have an alternative at that point, and they were already diverting them to Libya, and it was likely they were also going to Qatar, so we assumed that they were also going to go to Azerbaijan. And here we have a TB2, obviously very clearly Azeri. So once again, I mean, in the opening hours of the war, we started getting media requests asking about, if our research was relevant for tracking these. And then, as you know, a couple days later, we started to get sent images from actual drone strikes and from operations. So here are some examples, again, looking at the graphical user interface. These are just surveillance operations on the right. So we can actually look and see footage from operations released by Turkey, which we have in the top left and top left and bottom left. And then we can match these with operations flown by Azerbaijan in the war in Karabakh, top right and bottom right. And obviously the graphical user interface is congruent. So at this point, we can make the assessment that all of these airstrikes were actually being facilitated by Canadian hardware. Once again, the government of Canada never authorized the export of these sensors to Azerbaijan. That was our assessment at the time, and that turned out to be absolutely true. So this is diversion. Not only are they being diverted, but they're actively being used in a conflict which the government of Canada was also not a fan of. But there was also allegations that these strikes were breaching IHL. So in the following days, we also started to get more images, or the initial images of downed Westcam sensors in the conflict zone. So these were on Bayraktars that were actually downed in the conflict zone. To my understanding, Azerbaijan lost 2 TB2s out of their 23. One was shot down, one crashed. The people on the ground were very smart to immediately get as many photographic evidence of this as possible. This was actually a video, and I remember when this came out, it was very clearly the highest quality video of a downed Westcam sensor we'd ever seen. Videos are, in this situation, much better than photos for reasons that that it's harder to manipulate them, so they're easier to verify. And we had several more photos. This is what we've kind of described as the kill shot, and actually determining that absolutely Canadian sensors were diverted to Azerbaijan to be used in Karabakh. So all in one frame, we actually have the wing of a Bayraktar TB2 with an Azeri roundel, very clearly an Azeri drone. We have the sensor itself on a table. Well, is there a laser on this? It's fine. So in the center of the table, we also have a base plate. It's hard to see from here, but it actually says Westcam on it. We also have 2 Armenian soldiers in Armenian camo, which is distinctive from Azeri camo. So we can say, very clearly these look like Armenian service members. And we also have someone holding up an Armenian language newspaper with the date. So all in one photo, we can conclusively say, in addition to all the other evidence we had, that absolutely these Canadian sensors were diverted to the conflict. So what happened next? Long story short, Canada actually canceled the further export of these sensors to Turkey due to their diversion to Azerbaijan. Once again, obviously illicit. This was a good thing that Canada did. Canada was operating as required under the Arms Trade Treaty. Myself and Chris actually testified in Parliament about this. However, at the end of the day, this is really too little, too late. The damage done by this Canadian hardware in the conflict is obviously very clear. The role of the Bayraktar TB2 in the war was quite decisive. It took out hundreds of armored vehicles, dozens of tanks, and it was very difficult to actually take it down. So although it's good that the Canadian government did stop providing it to Turkey, as was the obligation, as it stands, it was really too little too late. And I mean, there's outstanding questions how the Canadian government really didn't know that these sensors were being diverted to Libya. I mean, you know, we're a small peace organization, and we can find this out. Global Affairs Canada is a major, you know, represents a major country with staff overseas. So there are questions with, as regards to how this wasn't discovered earlier, but those remain unanswered. So a couple more thoughts on the TB2 itself. So as it stands now, this drone no longer relies solely on Canadian hardware due to the export ban. It's had to start relying on European alternatives. From the day that Canada initially suspended the export of these sensors to Turkey in October 2020, the Turkish government came out and said, well, we actually don't need your drone or your sensors. We have alternatives. We assessed that to essentially be a lie at the time, and it's turned out that is the case. Turkey has failed to actually procure or develop a domestic alternative that rivals this hardware. So they've had to buy into different European markets to acquire them. It's likely at some day that Turkey will actually develop one that is that does rival a Westcam sensor, but not at this time. So as mentioned as well, it's documented that Azerbaijan lost two of these UAVs in the conflict. So that means that 21 remain. One of the negative aspects of the proliferation of these weapons is they reduce the initial cost of a war going hot, right? The thing with a UAV, which is one of the reasons why they're really pursued by many countries, is it's a way to attack your adversary without losing any of your forces. So if and when Azerbaijan was going to spur another offensive, this reduces the cost of them doing so. So once again, the proliferation of this technology was really a failure in many ways in terms of Canadian arms controls. This should have been caught well before it was. And once you open a Pandora's box, in relation to the proliferation of weapons, it's very difficult to close it, right? You cannot get those weapons back, and certainly that will not be the case with Azerbaijan. So some key points just to finish up here. I see I got 30 seconds left. You guys didn't hold up the cards. You're relying on me. Oh, did you? Okay, I'm so sorry. I kept looking down here. So I got 20 seconds left. So all I'll say is this was an absolute abject failure of the Canada's domestic control regime. Canada does now actually face stronger arms control obligations since when it started exporting these weapons, namely the Arms Trade Treaty. However, the peak of these exports was actually after Canada had already acceded to the treaty. So I think that this should serve as a case study for how other ATT states parties should control and regulate the flow of weapons, or else this is likely to happen again. Thank you.
Thank you, Mr. Gallagher. Our next speaker is Philippe Larochelle, a founding partner of Larochelle Avocats, a firm specializing in litigation based in Montreal, Canada. Mr. Larochelle has developed a unique private practice that brings an international human rights perspective into national cases since 1998. Mr. Larochelle's distinctive experience has permitted him to advise organizations on strategic litigation in the field of human rights in Haiti, Chad, Rwanda, Ethiopia, China, and Mali. He is also active in the field of Indigenous peoples' rights, where he acted on behalf of the Assembly of First Nations Quebec Labrador and secured recognition that the treatment of Indigenous women in Canada amounted to genocide in front of the National Inquiry into Missing and Murdered Indigenous Women and Girls. Mr. Larochelle has been practicing in international criminal law before the International Criminal Tribunal for Rwanda, the International Criminal Court in the Netherlands, and the Special Tribunal for Lebanon, also in the Netherlands. Some of his most notorious achievements were the acquittal of the Minister of Foreign Affairs of Rwanda, Mr. Jerome Bikamampuka, and the acquittal of Jacques Mungwawer of genocide before the Superior Court of Ontario. Mr. Larochelle also brought 2 successful claims against Canada before the UN Committee Against Torture and a successful claim against Rwanda before the African Court on Human and People's Rights. Mr. Larochelle, please.
Thank you very much. Thank you to the organization for having me here. I think it's a lovely event. It's a great country. I discovered it has very robust border controls and also delicious alcohol. I brought my Canadian gin, but I didn't need to rely on it. Other people took care of that for me. So and thank you for Mr. Gallagher. The presentation about the use of Turkish drone in the Nagorno-Karabakh war was very interesting. And my thought was, how can we take this further? And how in the aftermath of the war, where there were victims, there were schools and hospitals that were destroyed, there were displaced people, there were a lot of casualties. Where can we take this? And are there any forum where these victims can actually seek the remedies they are entitled to under international law? There is a very strong text that was adopted by the General Assembly of the United Nations, which clearly sets out the rights of victims to obtain reparations following violations of grave international humanitarian law, or other violations of human rights. And I invite you to read that text because it lays out comprehensive remedies that should be available to victims after war and after these violations. Why Canada? I think Mr. Gallagher has laid out for us, because during that war, Canadian technology was exported to Turkey and diverted to Azerbaijan and used in the commission of international human rights law violations. For the sake of this discussion, I will assume that we can link the use of these drones to actual victims and violations of international human rights law on the ground, and discuss whether we could bring a claim against Canada based on the fact that this technology ended up in the wrong hands and were used for other uses that were stated in the documentation that led to their export. So what is WESCAM? I think I don't need to expand on that. Mr. Gallagher did it for us. The export permit timeline, Mr. Gallagher also provided information about that. And we know that these drones, there is a detailed timeline of exports here that I will not spend too much time on that, because I want to go further into what could be a possible strategic litigation based on what happened before the Canadian courts. What is interesting, though, is that some of the timeline that there were phone calls between Erdogan and Trudeau at key moments where Turkey was seeking more of this Canadian technology, and Canada was pondering and deliberating whether they should resume exporting it to Turkey. So that's the law that regulates when and how weapons should be exported from Canada. And there are two important criteria that you will find over this in this screen. The first one is whether the export of a given weapon would contribute to peace and security or undermine it. And the second one is whether the weapon could be used to commit or facilitate the commission of a serious violation of international humanitarian and human rights law. These two first criteria are known collectively as the negative consequences. And so basically the export of those weapons are regulated, and before a permit for their export can be issued, the minister has to assess whether these two criteria are met or are likely to occur. And before deciding to issue such a permit, the minister must conduct what is known as a substantial risk assessment, taking into account possible mitigation measures. And these possible mitigation measures are buried in the regulations to that law. But what is important is that they are meant to prevent diversion, about which Kelsey spoke earlier. And they allow the minister, it's not an obligation, but they allow the minister to seek from the country that wants to secure the importation of these goods an end-of-use statement and other statements about how the weapons are meant to be used, where, and especially as we discussed earlier, and especially whether they're going to be transferred to another country. There were a lot of talks about the issue of end-use insurances. Some of these talks were between foreign affairs ministers. Some of these talks, as I said earlier, were between Erdogan and Trudeau himself. And people have managed under the Access to Information Act to obtain a lot of interesting documentation about what took place. I have inserted some of these emails from Canadian civil servants about being exchanged at the moment where there are issues with the use of those drones in Azerbaijan. And when I was pondering about how could we do this, I think there is a very interesting parallel to draw between the substantial risk test that the minister has to perform before allowing the export of weapons and the substantial risk test that is performed when the Canadian government seeks diplomatic assurances before sending out someone to a state that is seeking to prosecute them in their own in a third country. And in both cases, whether they're called diplomatic assurances or end-of-use statements, these statements are meant to address the substantial risk, in one case, that the person will be subjected to torture, and in the other case, that the weapons will be diverted or used for other means that they were meant, that the use that was stated in the documentation seeking to have permits issued. And so the key issue with the WESCAM permits is whether after end-use assurances, there remained a substantial risk that they would be used, that they would be diverted, or that they would be used for other ends. I'm drawing the parallel based on a case from the Supreme Court of Canada called India against Badesha. You have the references here, the reference of that case here. Badesha was the case where someone was requested for extradition by India. And the Supreme Court of Canada assessed the diplomatic insurances mechanic, if you will, in the Badesha case. And I decided to draw the parallel by taking out some of these criteria that could be relevant in assessing whether the end-use assurances that were provided to the Canadian government would be satisfying the test, which is, are they alleviating the substantial risk that these weapons will be diverted? So how would some of these criteria transfer into assessing the effectiveness of the end-of-use assurances that were provided by Turkey? I've worked in cases where the Canadian government extradited someone to Mexico after receiving diplomatic assurances from Mexico that the person would not be tortured. And this happened on the first day after he was deported to Mexico. And we won. This is one of the cases we won before the Committee Against Torture, because after obtaining all the documents under the Access to Information Act, we realized that despite the fact that Canada had secured diplomatic assurances to obtain the extradition of Boily, the people in the Canadian embassy in Mexico were not even aware that such diplomatic assurances existed. They were buried somewhere in a drawer, and Boily was sent to the same prison where he had escaped and subjected to torture as soon as they could get their hands back on him, of course. So one of the first criteria in case of torture is whether the human rights record of the government is an assessment of the human rights record of the government giving the assurances. Sorry. We heard earlier that Canada suspended the issuance of new licenses to Turkey on October 11, 2019, because of the military incursion into Syria. So a first alert, if you will, or a first red flag about dealing and allowing weapons export to Turkey is the fact that it was deemed that this incursion in Syria could further destabilize the region and worsen the humanitarian situation. This is an assessment of the Kenyan government itself. Another red flag, Libya. There was an arms embargo over that country, and it was found in the second report that Turkey not only violated the arms embargo, but violated it by supplying this exact technology that we're talking about today. And they found that there was deliveries of those drones equipped with the Canadian technology, despite an arms embargo. You remember that this is November 2019. So a mere few months later, in April of 16, 2020, the suspension of the issuance of permit was lifted. So that's another bigger red flag about what the kind of factors you should assess before you can rely on and use assurances from that country. You've already received warnings on at least 2 occasions that you cannot rely and you cannot trust Turkey as a commercial partner to honor its commitments. Another factor that was mentioned in Batesha is the relation between the countries. So here between Canada and Turkey. This is an extract from some of the documentation that was obtained. In April, the conversation between Erdogan and Trudeau occurred in April, the same month where the suspension of permits was lifted. So here you have a quasi-judicial exercise that should be performed by GAC, Global Affairs Canada, and you have that distortion of bro or Erdogan calling his bro Trudeau and saying, bro, let it go. We need them. And we can, it's interesting that the Access to Information Act is a powerful tool that should not be neglected in pursuing litigation of that sort, because even if you will see on other slides that it is heavily redacted, you still manage to catch some interesting niblets here and there that you can use. So of course, economical considerations, NATO ally. So you have all these things coming into play, and the direct contacts between the leaders of the 2 countries. There were, even despite Trudeau's bromance with Erdogan, there were pieces of warning that were issued in the parliament, and other experts contested the fact that these permits were issued. So it was not a unanimous thing, and there were, over and above the red flags that we already discussed, there were other signals that the Global Affairs Canada should have been careful before allowing, including our friends here who participated in parliamentary commissions. So that's the real question. Did Canada prioritize its economic and strategic relations with Turkey over possible negative consequences? I put you back to what those negative consequences are. And we know the importance of these exports. We know also how closely and how it was done. We know that there were lobbying taking place. We know that there were more calls between Erdogan and Trudeau. So there were a lot of efforts from Turkey to actually secure the lifting of the suspension of these permits. Another factor is the specificity of the assurances. This factor, knowing that Turkey had diverted the weapons on at least 2 occasions in the past, before resuming sending weapons to Turkey, there should have been an effort in securing more specific assurances and use assurances before sending them over, and particularly the fact that the increasing military cooperation between Turkey and Azerbaijan was well known, and it was out there in the media. It was a big organization such as Global Affairs Canada should have been aware that there was a substantial risk that the weapons could be actually sent over to Azerbaijan. There's a lot of material out there in the open that the people from Global Affairs Canada could have catched, alerting them of the possibility that Azerbaijan was the ultimate end user of that technology and these weapons. This is just to show you some example of what you receive when you get emails between those people who are, in their offices in Ottawa trying to figure out whether they should allow the export of the technology or not, and performing the assessment of whether the weapons should go, while Trudeau is on the phone with Erdogan. So as I'm saying, it's a bit there's a bit of a disconnect between what takes place in the higher spheres and what is actually taking place in the offices of Global Affairs Canada in Ottawa. The monitoring of the assurances. So once you know that they were diverted or you have suspicion that they were, then you have obligations under the Arms Trade Treaty, to which Kelsey referred, to seek explanations, to investigate. And after Canada started receiving information that the weapons had been diverted to Azerbaijan, you will see here the kind of responses they received from their Turkish counterpart. Interestingly enough, Erdogan stopped calling just at that point, when the Canadian military people in Ankara are trying to know what happened. Where are the drones? Where are our cameras that were meant to remain in Turkey and be used by your police forces or for defensive purposes? Well, we won't. I mean, you know, we cannot expect a timely and detailed response. And you will see the other one here. We don't have any problems connecting with the Turkish military. It would be interesting to be able to read the whole of that email, of course. And this is something that you can hope to achieve through litigation, where it's not only request to Access to Information Act, but you can depose these people, and the privilege that they can raise to oppose the disclosure of that material is much more narrow. We're hoping they're going to be a bit more forthcoming. In the case of torture, there's an increasing body of documents and articles that are very critical about the mechanic of diplomatic entrances, which are too often used as a way to bypass a state's obligations and allow extradition or get rid of people that or satisfy other states or partners' requests for extradition. And my submission is that this would equally apply to assurances that were sought and received by the Canadian government from their Turkish counterpart. We know, with all the red flags that were available to them, it was clear that there was a very strong risk that the weapons would be diverted and used for other purposes. Here's another email showing how the people in Global Affairs Canada were somewhat baffled by what was happening. They are still wondering. September 27, 2020. Are there restrictions in our export of in our export permit process? So there seems to be a bit of miscommunication as well before the different people working on the issue. I realize my time is up. But one thing possible litigation, of course, include the government of Canada, which could be sued for torts, that were committed following its, call it reckless negligence or willful blindness. There is definitely something worth warranting exploring to sue the government of Canada for what happened during the war in Nagorno-Karabakh after they issued those permits. But one other area, which I realize exists also after reading the Arms Trade Treaty, is that under Article 11.4 of that treaty, once weapons are diverted, you're supposed to follow up with measures through investigation and law enforcement. So there is enough information available to the government of Canada to investigate and seek possible remedies and repairs from those who have diverted those weapons. And from the record I've seen, and I have no indication that even after the Libyan diversion, even after the Syria problem, even after the Nagorno, the Azerbaijan diversion, that this has been done. And it would be possible to explore that as a possible remedy as well, to try to force the Canadian government to follow up on the end-use assurances that were not respected. Well, I guess that was all my time. Thank you for allowing me an extra 30 seconds. Thank you again.
I'd like to introduce our final speaker, Professor Christopher Waters from the University of Windsor. Dr. Waters joined the Faculty of Law in 2007 and served as Associate Dean from 2009 to 2012, then served as the Dean of the Faculty of Law from 2015 to 2021. He has been a visiting scholar at several universities, including Omar Sy University and the Asser Institute in The Hague. Dr. Waters' research interests are in the areas of public international law, international humanitarian law, law and politics in the South Caucasus, and active transportation and the law. He has extensive human rights and election monitoring field experience in Eastern Europe and the former Soviet Union. Dr. Waters is also co-editor of the Canadian Bar Review and is on the editorial board of the Journal on the Use of Force and International Law. Dr. Waters, welcome.
Good afternoon, Baref. What a pleasure to be here. Thank you, Christina, for the introduction. Christina started by saying this will be an interesting panel on Canada. That sounds like a cruel joke, right? There's no such thing as an interesting panel on Canada, but this is, and my thanks to my colleagues. And I also want to say that the most important part of my bio, actually, and this wasn't on what you had, Christina, was that I taught here at AUA 20 years ago, and what a pleasure it is to be back here. So many thanks to the organizers for the invitation to be here. So my colleagues have talked about Artsakh, about Nagorno-Karabakh. I'm not going to spend much time on that directly. You heard from the folks who did the technical deep dive to make any of the discussion possible. And so the work at Plowshares, as well as, of course, people on the ground here in Armenia and in Nagorno-Karabakh, is absolutely crucial to establishing anything that Philippe or I are talking about today, right? Because without that kind of evidence, the rest of it, it just becomes sort of hypothetical. And I'm going to pick up where Philippe left off, in a sense of, okay, we know there was Canadian involvement. What do we do with that? And I want to make some more broad conclusions, but I think that that's a nice point of departure, so to speak. Okay, this is from an ICRC document called Bringing IHL Home. There's a widespread recognition that international humanitarian law, while you could quibble with it, while you could modernize it and so on, is an important body of law, one that holds out the possibility of real protection for victims of armed conflict. But there's also widespread recognition that there's a gap in implementation. And the ICRC, the International Committee of the Red Cross, which is considered the guardians of the Red Cross internationally, put out this document. And I think it's an important document. It talks about domestic legislation, treaty participation, and so on. In fact, there's no treaty that's more widely ratified than the Geneva Conventions, right? The 4 Geneva Conventions. But there's one thing that I think is missing from here, and that is the possibility of civil liability for breaches of international humanitarian law. Now, you don't see that on here, partly because this document comes out of a conference of the Red Cross and Red Crescent movement, the broader movement. And of course, that involves not only the Red Cross and the Red Crescent societies nationally, the Federation, the ICRC, but also states parties. And states aren't super keen on encouraging litigation against them. And so I think there's actually a gap in the sense of you don't see the idea of compensation for victims of armed conflict breaches or the idea of deterrence through civil suits in this area. And states are very nervous about these kind of topics, which they sometimes, or their defenders sometimes label lawfare. Right? So just, in terms of an overview, there are gaps in each of these categories, but conceptually at least, state responsibility and individual accountability can be pursued both by international courts, Myanmar, Gambia versus Myanmar, for example, Armenia versus Azerbaijan, at the ICJ, litigation for the European Court of Human Rights, and so on. And there are, of course, gaps here, very restrictive jurisdiction, for example, of the International Court of Justice, a culture at the International Court of Justice, which is one of making the most narrow decision possible, and so on. But at least conceptually, there are avenues to pursue state responsibility in the same way that there are avenues to pursue individual accountability. So in Canada, for example, the War Crimes and Crimes Against Humanity Act, and Philippe has direct experience in litigation involving war crimes accountability in Canada. But again, there are gaps here, including prosecutorial discretion. So for example, how many war crimes prosecutions have there been in Canada under current legislation? 2, 1 conviction, 1 acquittal, the one that Philippe secured, and no others since then. prosecutions simply won't bring additional war crimes prosecution. They'll bring some administrative measures, some immigration measures, but a real reluctance to pursue war crimes accountability before Canadian courts. And of course, internationally, it happens as well. And our reflex is always to go immediately to the International Criminal Court. But even by design, the International Criminal Court was designed to prosecute the most serious crimes of concern to humanity as a whole, right? Not the sort of small fish, everyday garden variety of war crimes litigation. Skip. I don't want to get that red flag. It's frightening. Yeah. Even though it's small and it's held up very delicately, I haven't even got my yellow yet, and I'm already preempting my behavior. So there's a scholar named Rebecca Krutoff who writes about war torts. And she writes, the lack of a legal, well, I'm not going to read it off. Everyone is quite literate here. But essentially, she says, she identifies this gap as well and says, what can we do towards greater accountability for civilians in the civil context? Now, there are a bunch of obstacles here. Let me say two. One is that there are limited causes of action, right? We heard earlier this morning in the panel on corporate responsibility for violations of international humanitarian law that the scope of the Alien Tort Claims Act in the US has shrunk significantly, although there were some shreds of hope with the Nestle decision fairly recently. But nonetheless, the Alien Tort Statute is by no one's account some sort of panacea to pursuing violations in the United States, even when those violations involve the law of nations or the treaties of the US. Similarly, whenever there are attempts to pursue civil liability, various defenses are raised, defenses such as combat immunity, the idea that we couldn't prosecute soldiers for negligence, for example, because then they would fail to adequately carry out their mission. They would always be looking behind them for the lawyers, right? The idea that the militaries are becoming legally encircled, or that lawfare is some pernicious notion that will prevent soldiers from adequately carrying out their jobs is sort of what's behind this notion of combat immunity, but it's not the only one. Of course, we have the notion of sovereign immunity, but also in some Commonwealth countries, in particular in England, you find the active state doctrine, which is similar but related. Basic notions of justiciability. We're not going to handle this. This is an executive matter. It's foreign affairs, it's defense. It's an executive matter. It's not a matter for scrutiny by the courts. Or very restrictive readings of private international law. Forum non-conveniens. This is not the appropriate place for this to take place. This is, but under very sort of restrictive versions of that. And then in just general judicial deference and notions of judicial economy. The ever-present floodgates argument, which we hear regularly. Well, I think there's one bit of hope coming from Canada in terms of the jurisprudence, and that comes from a case called Nebson Resources versus Araya. This is a recent case in Canada, and it comes from Ethiopian people who were, 3 plaintiffs in particular, who were drafted into the Eritrean military and were then forced into labor at a Canadian-owned mine in Eritrea. Okay? And the plaintiffs accused the company, Nebson Resources, of slavery, cruel and inhumane treatment, of forced labor, amongst other, and crimes against humanity, amongst other things. And the question before the court, which ultimately went to the Supreme Court of Canada, is there a common law tort remedy for breaches of customary international law? The answer by the majority of the court was yes, very possibly. You have here a photo of Justice Rosie Abella, who was perhaps not insignificantly the first refugee appointed to a bench anywhere in Canada. She retired last year. She was also the child of Holocaust survivors born in post-war Germany. And very much this was one of her last significant judgments. And she writes a really, and honestly, read the judgment, her judgment. Don't read anyone else's judgment. Read her judgment. It's actually beautiful. She talks about human rights law being the phoenix that rose from the ashes of the Second World War. But she goes on from that sort of flowery language to say, it wasn't just meant to be legal notions. It wasn't just meant to be, as she calls them, legal luxuries. Where there were rights, there were meant to be remedies. And so she said, let's take this traditional understanding that courts should be deferential wherever there's some kind of foreign affairs issue involved. Let's turn that on its head and let's evolve the common law. And a number of obstacles were posed. First of all, whether customary international law could automatically be considered the law of the land in Canada. Now, we'd said that before, courts had said that before, but to what extent was it true? And did it only go to prohibited acts, or did it cover all aspects of customary international law? And Justice Izabella, for the majority of the court, said, yes, if it's customary international law, it's automatically the law of the land in Canada. If if we have a different system of implementation, if it's treaties, right? The parliamentary sovereignty, Parliament can do what it wishes, within reason, of course. But if it's customary international law, unless there's contrary legislation explicitly excluding the operation of customary international law is the law of the land in Canada. So that's A. B, there are certain norms of customary international law, so-called Jus Cogens norms or preemptory norms, such as the norm against slavery, the norm against crimes against humanity, that these should receive super protection within Canadian law. So Justice Izabella argued for the majority. Customary international law exists as part of Canadian law, although there is no specific tort of slavery, for example, or no specific tort of crime against humanity in Canadian law. We're going to accept it as the basis for tortious responsibility. We're not going to make sure that it has to come through the traditional law of battery or assault. We're going to allow it to simply be imported and tried out at the Canadian court level. This is a really significant decision for Canada. And I don't know of any other common law jurisdiction that has done this, that has said on the basis of customary international law alone, you can pursue corporate accountability. And I think there's some really important implications here. Now, the implications for the plaintiffs in this case was that Nebson quickly settled the matter. Okay? So as soon as the Supreme Court of Canada came out, a monetary settlement was reached. Now, I should say that the Supreme Court of Canada was not saying definitively that this kind of corporate accountability existed, but it refused to strike out the matter at the first instance. So it still has to develop in the jurisprudence. We'll see how this goes. But with advocates like Philippe, and I increasingly think we should pursue a lawsuit against Westcam, the manufacturers, if not the government of Canada. And I think Nebson gives us the ability to do that. We say there's been a breach there's been a crime against humanity. Westcam was at least negligent. Certainly the government of Canada was. And I think the government of Canada can be sued here as well. And one of the points, just as a footnote, if you'll allow me, I said I wasn't going to talk too much about Karabakh, but a footnote, if you'll allow me, is that the transfer of weapons to Turkey never should have happened, right? And in one sense, you can say, well, governments are busy, they make mistakes, they had end-use assurances, they were naive Canadians, perhaps. But in fact, there's a pattern of transfers of arms to human rights abusing regimes. Canada has transferred unmanned, I've got unmanned aerial vehicles in my mind. Kelsey, light armored vehicles? Thank you. I think drones all the time. Light armored vehicles to Saudi forces, where we know definitively they've been used to commit human rights abuses in Yemen. This is not some pattern. This is not a simple act of naivete. There's a pattern of transfers to human rights regimes, and very much a willful blindness on the part of Canadian authorities, who now say, of course, well, we're operating under a different regime. It's the Arms Trade Treaty. We'll be more careful. But it's not like there were no prohibitions on transfers of weapons before the Arms Trade Treaty. It's relatively recently ratified in Canada. The Geneva Conventions talk about a responsibility to prevent, right? What does the responsibility to prevent mean if not transferring dangerous weapons to rights-abusing regimes? Okay, now I go back to Nebson. I just got that off my chest. So there's a couple things about this. We don't know where this case will go. It was only on the preliminary matter. There was a very strong dissent by several of the judges who said, this is no business of the Canadian courts. Judicial deference, judicial economy, deference to the executive on matters, deference to other jurisdictions on how they protect workers' rights or fail to, and so on. But we'll see where this goes. But I think it's really exciting. And of course, you still have the problem of sovereign immunity, but states rarely act without private actors these days, right? We heard this morning about mercenaries coming to the Karabakh conflict. I'd love to know what airlines carried them, right? I think I could see a potential claim against those airlines. I could see a potential claim against Westcam, and so on. So I'm going to stop there. Thank you again, Chat merci, and thank you to my fellow panelists.
Dr. Waters, I saw Guyana about to hold up the red card and you ended it right before. She was like coming up with it, and then the thank you slide came on. You did it. Good job. All right. If you guys don't mind, we have a few questions for you guys. So one of the questions is, what are the prospects of bringing a lawsuit in Canada with respect to Westcam, the Westcam sensor being exported to Turkey, and who would be the plaintiffs?
Well, let me answer the first part of that question, because I think that was essentially what I was suggesting, is that, was there a crime against humanity? If yes, then it can be prosecuted theoretically in a Canadian court if there's any kind of Canadian nexus. There is. It was a Canadian operated mining company. Sometimes the courts have refused to sort of pierce the corporate veil, but ultimately the lower courts already found that in Nebson, the Nebson, the Canadian home company, was responsible for what happened at the mine. I think it's very clear to be able to say that Westcam produced those. Kelsey's organization, Project Plowshares, has done I think a very thorough and definitive assessment of the fact that these were Canadian Manchester weapons used in Azerbaijan, in Nagorno-Karabakh, and really no one has quibbled with that, I think, at this point, right? Now, I would add the second part of that. For the second part of that, I would suggest we go to Philippe, because he's the actual practicing advocate, and in terms of what the mechanics of this might look like.
Just to follow up, we could consider a class action on behalf of victims in Nagorno-Karabakh. So they could, if there are several victims that could join their efforts, they could be plaintiffs in the Canadian court. And the president of Nebson, the plaintiffs were not located in Canada at all. The plaintiffs were located in Eritrea or Ethiopia, where they launched their claim from. So the fact that the company was based in Nebson was based in Vancouver, I think this is a case from British Columbia, was no obstacle to these people bringing a case before the Canadian courts. And one, we're considering suing Canada, suing Westcam. I think suing both could bring an interesting dynamic, and looking into what did Westcam knew, what did they told the Canadian government in order to obtain the permits, what document was provided. We have nothing about that. Nothing was obtained about these documents so far, but turning Canada against Westcam, maybe Canada, well, they they provided false information, or there would be an interesting litigation path, taking these two, possibly one against the other. And again, in the Boily case, a lot of the it is still litigated before the federal court, because they were deemed to be negligent in follow up on their diplomatic assurances. A lot of the interesting material was actually generated through civil litigation and depositions. Definitely what was obtained through the deposition was the ground for some key considerations of the Committee Against Torture in finding that Canada had violated the convention by allowing the extradition of Mr. Boily to Mexico.
If I could just add to that, I am not a lawyer, by the way, so just to get that out of the way, but I think in the conversation regarding bringing legal actions against arms dealers, of which Westcam is one of the things to consider is actually how export controls work. And this is conventionally the case, and this is absolutely the case in Canada. When a manufacturer is seeking to make good on a deal and export weapons, they have to apply for export permits, sometimes called licenses, to actually transfer those weapons to whoever the recipient is. And in doing so, they provide information. They provide information for who the end user is. In this case, it would have been Turkey, which didn't end up being the case with some of these. However, it's actually the obligation of officials within our Ministry of Foreign Affairs, what we refer to as Global Affairs Canada, or GAC, to look at the recipient through the lens of the EIPA, which Philippe brought up, as well as the ATT. So my point being, really at the end of the day, the obligations primarily in a conventional sense are actually on Canadian officials. And whenever an arms dealer gets themselves into hot water for doing something dodgy, which is frequent, they will go back and say, and this has been the case in Canada more than once, hold your horses. We followed everything Global Affairs told us to do. We followed the law. We gave them all the information that was required. Go complain to Canadian officials. So I think that is one of the hurdles potentially. I mean, how to overcome that legally, not me to answer, not for me to answer, but we really kind of focus on Canadian officials as the really the actors who would be responsible. Arms dealers, arms manufacturers, these are private companies. They're going to sell weapons. They're also going to sell weapons to dodgy countries. And unfortunately, that's just what happens. So I think at the end of the day, a lot of the focus should be on governments because they are the ones that actually control the flow of weapons. But that is not to say that there shouldn't also be these exploratory conversations around looking at the manufacturers themselves, because of course, most of the time they're actually the ones pursuing the deal.
Really quickly, is there a statute of limitations on these types of cases? And if so, please don't say it's already passed.
It's subject to verification, but in a case like that, it's 6 years, I think.
Oh, 6 years from when?
Well, from when the tort occurred. so that would be from 2020, end of 2020. So that would be, so the limitations, that the limitation time would be 6 years after those facts.
It might, because statutes of limitations are provincial, so it might vary from province to province.
If it's a federal court, exactly. So we'd have to, because you could not sue the Westcam before the federal court, but you could sue the Canadian government. You would have an option. It's complicated. We have provincial court system and the federal one. When you're suing the Canadian government, you can look into suing them before the federal court or the provincial court, depending on what you are doing. Westcam would have to be sued before the Ontario courts. They're located in Ontario.
Where it's 2 years, unfortunately.
Yeah,
2
in
years,
Ontario it's 2 years.
Yeah, from discoverability. But so you could make arguments around discoverability. Yeah.
And sorry, last thing to add to that. I think anyone that is interested in looking into actually pursuing this, there has been cases where civil society organizations have actually pursued legal action against governments. One case for not respecting export control obligations. One case would be in the UK. An organization called Campaign Against the Arms Trade has brought legal action several times against the United Kingdom for not respecting their obligations under the ATT, Arms Trade Treaty, and I believe the EU Common Position, which they used to obviously be part of. So that would be one thing to look at, obviously where the precedent is. There was also attempted legal action by Dutch groups against the Dutch government, also actually for providing UAV parts to Turkey, I believe. They were unsuccessful, but again, these are things to look at.
Just to complement on that, it would be an interesting discussion. It would be interesting to continue the Nebson discussion and discuss what time limitation applies to crimes against humanity. There are some who would say that there is no limitation against for these things.
Another question is, how does the U.S. deal with armed trade treaties, given that its chips are used in the drones?
So that's a complicated question. So the United States is actually not a states party to the Arms Trade Treaty. The ATT signed the treaty, or rather the U.S. signed the ATT, and under Donald Trump unsigned the treaty. which is obviously not a legal term, but they are now considered to not be, pursuing to accede to the treaty. So they really are not part of the treaty anymore. The U.S. actually arguably has some of the most stringent arms controls in the world. These are not arguably for protecting human rights. It's actually for protecting U.S. defense interests and probably commercial interests. But if you are found to be disrespecting end-use assurances that were provided to U.S. officials, they will find out and they will go to the government in which they believe diversion is happening. This is pursued through a program called the Blue Lantern Program, as well as the Golden Century Program. And you do not want to upset U.S. officials if you're an arms dealer, because they will shut you down and you will not be able to export to anywhere. So there's a lot of kind of extraterritoriality going on there. As it relates to these chips, I don't know which one the question is referring to, but I'm assuming it's probably what we'd call a commercial off the shelf piece of equipment. Most of these chips are. The Bayraktar actually relies on a lot of these. So the reason why that's significant is it actually arms control obligations, export controls wouldn't apply to it. This is something you could probably buy off Amazon. And the Bayraktar is actually well known for being kind of cobbled together with a bunch of commercially produced parts. And when that is the case, it's really difficult to interrupt the provision of that equipment because it's not controlled. If it's not deemed a controlled item, it's really difficult to stop the transfer of those systems.
Another question is new litigation being developed in Canada to prevent technologies from being exploited to rogue states like Turkey and Azerbaijan?
Not to my knowledge. I don't know of similar cases or cases where the issues that we discussed today were raised in a suit.
Yeah, I don't know either. I have a question, and I don't know if it's Izabella or someone else might be able to answer, but is Armenia a party to the Arms Trade Treaty? It should be.
Yes, it should be. That would be advisable. And it would also help in these situations, right? Because other states parties could collaborate with government officials.
This is what litigation is about, to be creative and to try to force new issues into the courts like that. Because if you wait for the ICC, you might be disappointed. And but I think one other possible avenue of litigation that just on top of my head, when we see the obligations under the Arms Trade Treaty, and the fact that Canada had done nothing, one other areas of possible litigation is to bring a mandamus, by which you would try to force them to follow up on what was done and to investigate the use of these drones. Now that they have now that they know they've been diverted, now that they know they've been used in the war in Nagorno-Karabakh, it could be interesting to take it administratively and to just file for mandamus and try to force the government to act in that regard and respect its obligations under the Arms Trade Treaty.
I think this next question was directed to one of you. I don't know which, doesn't have a name in it, but it says, you mentioned it was a failure of Canadian export controls, but is there culpability for L3? How much does L3 spend on lobbying and political giving in Canada?
In Canada, I mean, off the top of my head, I'm not sure. So the company, these sensors are made by a company called L3 Harris Westcam. Westcam is actually a well-known Canadian sensor manufacturer. They actually started as a commercial operation and then moved into the defense market and were later acquired by L3, which then had a merger with Harris in, I believe, 2015. So that is to say it's now owned by a U.S. conglomerate. L3 Harris is one of the biggest defense manufacturers in the world. They are kind of a good example of a big defense multinational. How much lobbying do they do? I'm assuming a fair amount. You can actually look this up. Canada does have a relatively accessible lobbying portal. I can't remember what it's called off the top of my head, but you can actually see where lobbyists are actually lobbying Canadian officials and broadly on what topics. I can't remember the first part of the question if there was one.
Culpability for L3, if there's any culpability.
I mean, their position is that Turkey told them that they were the end user and they know nothing more. And again, this is not the first time we've heard this. And so they were actually questioned by officials from Global Affairs Canada. This came out in some of the documents that Philippe was showing. And Westcam actually cooperated with government officials, which of course they should, and that would be advised. But they basically stated that, you know, Turkey gave us these end users, which Turkey said that we are the end users, the Turkish government. And past that, I mean, we really can't say much more. It's possible that Westcam knew more. It's arguable that technicians within Turkey should have known, working on these sensors, that they were being diverted to conflict zones other than those that they were supposed to be in. But obviously, we can't say that for sure.
I think that, and there's some really interesting litigation going on around arms manufacturers domestically in the US right now. It'll be interesting to see what happens with this. I actually think that one day this will be like smoking litigation. You know, the companies can't simply rely on the fact that the regulators had it prevented smoking. It depended on what they knew and whether their actions caused harm. The other thing one thing I didn't mention, but one aspect about bringing civil suit as opposed to waiting for the ICC or even waiting for domestic prosecution, is that you're operating under a lower burden of proof. It's balance of probabilities, not proof beyond a reasonable doubt or whatever it may be in your respective jurisdictions.
Another question is, what international rules, if any, regulate the sale of kamikaze drones, such as those sold by Israeli manufacturers during the 44-day war?
What kind of regulations? Again, it depends what arms control frameworks a country belongs to. The majority of world states are now part of the Arms Trade Treaty, which again is a good thing. So kamikaze drones, also called loitering munitions, these are small drones that are both the UAV and the weapon. So essentially they fly at their target and explode. And this is a rather new development. There has been conversations around how IHL applies. I know that those are ongoing. I mean, in terms of regulation for their sale, I mean, this is really kind of new stuff. So, you know, we would have to see end use assurances, all of that. But as this is new technology, you know, there's not really much to say how arms control obligations would change. They still exist as they exist.
And I think this might be our final question. I don't know if we have time for more, but how does the situation of Westcam export during the Karabakh War square with the export during the current Ukrainian war?
That's a good and another complicated question. How do they compare? So Canada has been supplying these sensors, the CMX-15Ds, actually probably an MX-15D, which means that it has American components in it, to Ukraine since about, by our numbers, since about November. Last year, they exported, the Canadian government exported approximately about $42 million worth. And these are being used on the Bayraktar TB2 that is being used in Ukraine. Exports to Ukraine right now, obviously it's a very complicated situation. Canada has continued providing these sensors to Ukraine, and the reason why they're providing them to Ukraine is because they can no longer provide them to Turkey, obviously. Turkey is the manufacturer of these drones, so Westcam is essentially circumventing the export ban by now transferring the technology directly to the country that is importing the drone, if that makes sense. It's kind of a strange triangle. So that's what's happening with Ukraine. In the past few months, Canada has actually started to the Canadian government directly transfer these sensors to Ukraine on the Canadian dollar. This is now military aid. This is no longer a commercial transaction. And when that happens, I'm speaking broadly here, governments tend to cut corners. When ministries of defense come in and say this is a national security issue, we typically see that not all rules are being followed, and that is our fear, certainly with the case with Ukraine. Ukraine absolutely has absolutely has to defend itself. I mean, no one is questioning that. But the mass provision of weapons, I think, outside of just Westcam, things like small arms could be problematic due to the risk of proliferation and diversion within the conflict zone.
Thank you very, very much.